here.
Good morning, Mr. Kims.
Hey, how you doing, buddy?
I'm okay. How are you?
Oh, I'm okay.
Good. Mr. Kims, I'm Judge McBurney, and we are doing a couple things today. It's your arraignment day on your case. Ms. Rios, who has been doing a bunch of work on your case and has filed some things, she's already filed a waiver of arraignment, meaning she's entered a plea of not guilty for you. That means the prosecution's going to get discovery to her so she can talk to you about what evidence the state has. Ms. Rios has also filed a motion for a bond reduction, and that's what we're going to do. Since she's waived arraignment, I don't have to talk to you about the charges you face, although it may come up a little bit in the conversation we have about bond. But what we're definitely going to talk about is whether your bond should be reduced from what it's at now, and if it's going to be reduced, what's that going to look like? So we're going to get on the record in your case. This is 26 SC 000-598, State versus Kims. Mr. Kims is in court with Ms. Rios, his attorney. Ms. Willingham represents the state. And Mr. Kims, you were given a bond in September of last year, a $14,000 bond. But I don't know that part of what I would need to do, you don't have a bond at all on the kidnapping count. That's maybe part of the confusion. I don't know if Mr. Kims has tried to post the bond, but the bond he got in September, the kidnapping was dismissed, so maybe it was in connection.
Boston prison.
Okay, well, whatever it was supposed to be, what it is officially in the indictment is kidnapping. And you don't have a bond on that. You've got a bond for some other counts, but the bond and the indictment don't line up. So it may be that he shows in the system as no bond on something, but we'll address all that today. So it's $14,000 spread across some counts that some of which you don't face anymore. So let's work through all that. I'm going to hear from your lawyer. I'm also going to hear from the prosecutor. The prosecutor has asked for a little more time to see if Ms. Willingham, can get input from Ms. Smith. That's the person that you allegedly did these things to. We'll see what happens. Ms. Rios.
Yes, Your Honor. Mr. Kims is 47 years old. He's lived in Georgia for the last 7 years. Prior to being arrested, he was working at McDonald's as an overnight cook and a driver. He did graduate from high school, and he has 2 boys and 2 girls, ages 22, 20, 12, and 14, and he's an active father in all of their lives. He's been in custody for about a year now, and he's not able to make his bond. I think separate from the issue of him not having a bond on that case, that the bond is just too high for him to be able to afford. I do understand the nature of these charges, but again, at this point, they're allegations, and he's maintaining that this does not would happen the way the state is alleging that it happened, especially the kidnapping. Since she did come to his location, that's the extent I'll probably get into with the facts. But I'm asking for the bond to be reduced to $5,000, and I understand that's low, but that's the most he would be able to hope to make.
Okay. And you don't think there's anything else holding Mr. Kims? No holds from other places? I don't see anything in the system. Okay. Tell me your understanding of the connection Mr. Kims has to Ms. Smith. Is this a stranger, ex-girlfriend? Not the mother of any of the 4 kids?
No, Your Honor.
Okay. All right. And Mr. Kims, where did you live? Ms. Rio said you've been in Georgia for 7 years.
It's kind of what backwards. I've been here since I was 7 years old.
Okay. So you've been here for 40 years.
Yeah.
Sorry.
Got it. That's okay. She got her wires crossed. All right. So you've been here for a while.
Yeah.
Got it. Okay. Anything else at this point you want to add, Ms. Rios?
No, Your Honor.
All right. Ms. Willingham.
Yes, Judge. I was gonna address the length of time that the defendant has been here, 'cause he has a lengthy history for the time that he's been here in Georgia.
Yeah, I'm just looking through the local jailings and we go all the way back to 96.
That is correct, Your Honor. With most of the cases early on being, simple batteries, but even in addition to those misdemeanor charges from the 90s, the defendant had an FTA in 1998. He had a violation of controlled substance in 2001, a probation violation in 2002, another one in 2005. Somehow he got a first offender for a drug charge in 2013, but that was discharged, it was successfully discharged, not quite sure how the first offender happened though. And then when this incident occurred, he actually was under a sentence of 10 years to serve 2 years with 5 of those years suspended. He was sentenced in that case, and that was a drug charge. He was sentenced in that case on May 22nd of 2022. So our case would have actually happened during the time that he was still under sentence. And that case includes a aggravated assault. So the defendant has quite a lengthy history that includes violent acts.
Do you have the indictment number for that?
It is 20 SC 174292.
Okay.
It is not the same victim, but I would have some serious concerns about the defendant's risk to reoffend. As we stand here today, it's been a pretty consistent history, with not many breaks. Oftentimes when we see cases where there's an old history, there's some kind of break. Here, it's pretty consistent from 1996 all the way up to present day, with the defendant having pretty consistent charges, and several violent offenses. So the state would argue that the defendant is a risk to reoffend. And as I've already mentioned, we have not, had direct communication with our victim. And that would also be a concern of ours if the defendant was released.
Okay. Mr. Kims, I didn't remember it, but your case from 2020 actually was a plea in front of me. You had Mr. Franklin as your lawyer and Ms. Hall was the prosecutor. You shot at someone.
Can I speak?
You're going to get a chance to talk in just a minute, but you may want to preview to Ms. Rios what it is you're going to talk about. 5 to serve 2 years plus some probation. Okay. Okay.
And I'm sorry, Judge, I do want to add, he also has a simple battery out of Louisiana from 2015.
Okay. Does your file contain any input from Ms. Smith? I know recently you haven't been able to connect with her, but I'm curious if there are any notations of, hey, as long as he stays away, I'm okay, or the opposite.
No, Judge, I get all of our contact up until this point has been with her mother. I have spoken with her mom a couple of times, but I have not spoken with the victim directly.
Okay. And does her mom offer any perspective, sort of secondhand, as to what her daughter? Okay. Got it. Ms. Rios, your client had wanted to say something. Have you decided he shouldn't say something?
You're not gonna say anything?
No.
Okay. Anything you want to add?
No, Your Honor.
All right. So, Mr. Kims, I am, in light of reviewing the case you had a few years ago, concerned that something like this came up while you were on probation for that. And so I'm going to leave the bond as it is and let Ms. Rios continue doing work on your behalf. She's going to get discovery. Ms. Willingham, is there anything complicated about the discovery in this case? Any reason why you can't get it to Ms. Rios ASAP?
No.
Okay. So Ms. Rios is going to get the discovery in this case, which is going to be witness statements or body cam or whatever's out there. She'll review it. She'll talk to you about it. And then she's going to work with you on deciding what's the best way to move forward. Let's get here for a trial. Is it going to be a plea? Is there something that needs to be suppressed because the police did something that Ms. Rios thinks wasn't the right way to do things during their investigation? She needs a chance to look at discovery and talk to you about it, and we'll take it from there. Okay?
Yes, sir.
All right. Thanks, Ms. Rios.
Okay.
And Judge, that concludes my visit for this morning.
Yes, if you don't have,
That's it, it was three.
okay. Are you Mr. Kimball?
Yes, sir.
Hey, I'm Judge McBurney. Nice to meet you. Mr. Kimball, you've been indicted for armed robbery and some other charges, picked up on a warrant. We need to get a lawyer for you because unless you're going to be hiring your own. I don't mean to presume that you're not bringing your own lawyer on board, but assuming you're not in a position to retain counsel, we need to get someone to represent you. The public defender, who would normally step in and give you very able representation, already represents a co-defendant in your case, so they can't represent you. You're entitled to conflict-free representation. Someone who's focused just on you, and the public defender's focused on a co-defendant. Are you planning on hiring a lawyer, or should I get one appointed to you?
Last time I came to court, that's what was told to me, that I was gonna get a lawyer appointed.
Okay, well, that's what we're gonna do. How long ago did you come to court?
I came on February the 20th. I've been here 4 months. I
Gosh.
haven't seen an attorney or talked to anyone about this case at all.
Okay, well, you and I are talking about it, but I'm not your lawyer. Let me see what's going on, because we need to bridge that gap and get you a lawyer. All right, so you may have been here on the 20th of February. That was the other time we had you on an inquiry calendar. And what should have flowed from there is getting a lawyer for you. But I will make sure today that we get the conflict defender's office focused on representing you. Let me check one thing, because there's a third defendant. I gotta make sure they're not already plugged in with that person. Nope, he's in the wind. Okay. So you need a lawyer. Okay. I apologize that this has taken a little bit, but we will get that fixed this week and have that lawyer connect with you. We'll need to bring you back so that we can handle your arraignment. Your lawyer will probably recommend waiving arraignment, but that's still a conversation we should all have. And I want to lay eyes on that lawyer so he or she can say, I've got Mr. Kimball and I'm handling this case. Okay?
Okay, when I had talked to you last month, you had said you was gonna talk about my bond today.
So we were, if you had a lawyer. We can't talk about bond without a lawyer on your behalf. And so I'm going to start making phone calls today, because I thought this was being taken care of. And in fact, before you came out here, I pressed the public defender a bit, and she showed me that she's actually made the inquiries that should have had the lawyer designated to represent you. So that lawyer, once we get him or her appointed, can very much talk about bond, and we'll do that. But we need to have that person in place, okay? Anything else?
No, sir, I just don't understand why I'm having to be here this long without knowing anything about this situation.
So I'm happy to tell you what the indictment says. I can tell you what's in the indictment, but you should be frustrated, and I'm not offering excuses. I'm frustrated with you that a lawyer hasn't connected with you yet. That's what I want to fix. I can relieve your confusion a little bit by telling you what it says in the indictment, but your lawyer is the one who can give you the guidance of here's how it'll work with bond, here's the discovery, these are the police reports, that kind of stuff. So you want me to tell you what's in the indictment?
Yes, sir.
Okay, let's do that. So, 2, 4, 5, 6. You are charged along with an Antonio Hayes and a Tanasia Hayes with the armed robbery of a guy named Charles Jenkins. And all this stuff that supposedly happened had it happened in February of 2022. And so you and the Hayeses supposedly took from Mr. Jenkins a cell phone, Visa debit cards, a gun, and a little over $600 in cash. You all committed an assault, an aggravated assault on Mr. Jenkins by pointing a gun at him. My guess is only one of you had a gun and pointed. It's usually not all three, but regardless, at least one of the three of you had a gun, pointed at Mr. Jenkins and said, "Give me your phone and your cards." Ms. Hayes alone is charged with going into this guy's truck. Mr. Jenkins had a Ford F-150, and she went in it. You and Mr. Hayes are charged with possessing a gun during commission of a felony. So maybe the story is there were two guns. You and Ms. Hayes are oddly on a different day, 6 days later, February 12th of 2022, you and Ms. Hayes are charged with shooting at a guy named Jonathan Voltaire. And then you're the only one charged in the last count, which is having a gun during this time when Mr. Voltaire got shot at. Those don't seem to be real connected to me, other than they're 6 days apart. This robbery of Mr. Jenkins and shooting at Mr. Voltaire. That's what's in the indictment. Don't talk about it. Don't say, "I have no idea what it is," or, "Oh my gosh, you caught me." You and your lawyer are going to talk about it. And you're going to be able to tell your lawyer, "I was in Texas in February of 2022," or whatever the situation might be. But you're certainly entitled to know what the allegations are. Those are the allegations. I'm going to get you that lawyer. He or she will come see you, and then we'll get you back here to do your arraignment, talk about bonds, and whatever else that lawyer and you want to talk about, okay?
Okay, about how long would I be looking at another court date?
Well, I want to move this one faster because what was supposed to happen between February 20th and now was that you would get that lawyer. So we would be talking today about bond, and you would already know what the charges are. So I'm going to try to have it happen in just a couple weeks and not I see you in a month, okay? But I'm going to get to work on it. I'm sorry that we brought you back here only for nothing to happen. That won't. When you are brought back next, it'll be because there is a lawyer in the mix, okay? I'll see you soon.
I'm hanging in there.
Hanging in there is good. You've been in jail for a minute, and Ms. Wood is working to get you out, but you have a bunch of business. So, Mr. Cook, you're here today for a couple things, but really we're just going to talk about them because Ms. Wood needs to take a few more steps before I think we'll be in a position to hopefully get you into drug court. No, take a global plea.
Yes.
I'm confusing two cases.
Rejected him, Judge.
Okay. So, Mr. Cook, you have new charges. That's one reason why you're here. And Ms. Wood has filed a waiver of arraignment, meaning she's entered a plea of not guilty for you. It's a second-degree burglary, the usual thing. You also have a revocation that's based on these new charges and other new charges for a bunch of old burglaries in the second degree. And what Ms. Wood is working on with the prosecutor on all your stuff, that's Ms. Smith, is to see if there can be a global resolution that'll take care of the revocation and this new indictment and what may be a few other, they may be what we call accusations, where everyone agrees, look, Mr. Cook's going to be pleading guilty to these other second-degree burglaries, but let's wrap it all into one thing, rather than we do a revocation for, I'm making numbers up, 6 months, and then you take a plea for 3 months and this and that. Just do everything at once. That makes a ton of sense, but it also takes a little bit of time. And so Ms. Wood has asked me to hold off on the revocation, handle today's arraignment, which we're doing, and then we're going to agree on a time to put you on another calendar that provides Ms. Wood enough leeway that by then she'll have negotiated with the prosecutor And when you come back, it'll be, let's resolve all these things. And there's not something hanging so that when we think we're done, just as you're ready to go, you get pulled back in.
Yes, sir.
Does that make sense?
That's a lot.
Okay. Ms. Wood, anything you want to add about Mr. Cook's situation?
No, Your Honor.
So we've got new indictment, revocation, and then some unindicted cases that we're going to corral.
Yes.
Okay. Ms. Smith, anything from the state?
Nothing, Your Honor.
Are you able to nudge your charging people to focus on Mr. Cook's uncharged cases?
Yes.
Great.
As much nudging as possible.
Okay.
And I'll get waivers in on those, so that will be helpful, I think.
Sure. How many other cases are there?
You.
Okay. Mr. Cook, all right. We'll figure out when we can get you back here. But the goal next time you're here will be to have that conversation about resolutions rather than, hey, I'll see you in a few weeks. Because one thing I know, while you are where you are, there won't be more second degree burglaries. You're just going to be earning good time. You get credit for all this time you're in. So while the prosecutor's thinking, well, gosh, all these cases, you might need to do X. Each day you are where you are, you're earning towards that number. Do you have questions about anything we discussed?
No, sir. One good thing. I was accepted to Must Ministries, which is a very structured program. It's an 18-month program.
Fantastic.
And I would really like to go there instead of other avenue.
Okay. It's what ministries?
Must Ministry.
MUST?
Yes, sir.
How'd you get in?
To a lot of prayer.
Okay. But like, how do you apply while you're in
They
custody?
went through one of your lawyers here, and I went through all the process, and it was like a 7-month process.
Really? And you were accepted?
Yes, I have the letter.
Well, I trust you, but the letter's a good thing to have. Do they wait on you? Because again, we're not going to get you back here tomorrow. It's going to
Yes,
take a
they-
little while.
They do.
Okay. And where is Must Ministries?
Sonoya, it's about an hour from here.
Okay. Maybe it's a slightly different name now, but I know people go to Sonoya and good things can happen. So good to know. Maybe Ms. Wood will factor that into what she recommends when we get to that point. Okay.
Yes, sir.
All right. I will see you soon.
All right, I appreciate you.
Thank you, Judge.
You're welcome.